and Mr. Phillips. Thank you.
Morning, my lads. My name is Sandra Minot Phillips, and with me is Jacob Phillips, and we are appearing for the Appellant, General Legal Counsel. My learned friends, Julian Malins, King's Counsel, Linda Hudson, and Bianca Samuels appear for the Respondent, Attorney Michael Lorne. My lads, I tend to just start with a few introductory statements, if you would permit me. This is a case, my lads, of professional misconduct by an attorney at law in which one of the sanctions imposed by the disciplinary committee was striking him from the role. On appeal by the attorney, the Court of Appeal upheld the finding of professional misconduct by the disciplinary committee, but it set aside the striking off and substituted it with a 5-year suspension and attendance at continued legal professional development courses. A principal issue for your Lordship's consideration today is what is the appropriate degree of deference that the Court of Appeal should have shown to the disciplinary committee on the facts of this case. The General Legal Counsel, of course, submits that had the Court of Appeal accorded to the disciplinary committee the deference it should have, there would have been no room for it to interfere with the sanction of striking off. Having said that, my lads, I'd like to just take you to the statutory regime briefly. And of course, the disciplinary proceedings fall under the Legal Profession Act in Jamaica. And I'd like to start by taking your attention to Section 3, subsection 1 of that Act, which is at EF page number 420. I'm sorry, my lads.
Sorry, my bundle isn't, electronic bundle isn't opening, so...
Just pause for a second until we can sort out this technical problem. Thank you very much.
No problem.
Somebody's coming, apparently.
Yes. We'll just sit on. I don't think we need to adjourn for this.
No, I don't think so. I can't open the bundle. You did it last time, but... Well, the big one isn't working. How'd you do that?
I think it may have just been the hold on. Yeah, I think it just took some time.
I don't know.
I just right-clicked to see if I could open it. So that's why you just
Okay.
did it. I think, yeah,
Thank you very much. Phillips, thank you.
Thank you, my lads. The Legal Profession Act, my lads, actually starts at page number 415 of the electronic bundle. But I would like to take you to section 3.1, which is at 420, if I may. Because it is section 3.1, my lads, that makes the upholding of standards of professional conduct the concern of the General Legal Counsel. And you will see it there at 3.1 subsection B. I would next like to take your lordships to section 11 of the same act, which is on EF page number 428. And this is just to show your lordships that in relation to disciplinary proceedings, the council shall appoint from among persons, A, who are members or former members of the council, or who hold or have held high judicial office, or who are attorneys at law, or who were members of a former disciplinary body, or who are attorneys who have been in practice for not less than 10 years, a disciplinary committee consisting of such a number of persons not being less than 50. And then I would like to take you to an important section, which I think is section 12 on page 429. And this is a section that deals with complaints to the committee. I am, of course, taking it that your lordships have already read the section, so I'm just highlighting various aspects of it. But if you want me to slow down, please indicate. In particular, I wish to take you to subsection 4 of section 12, which is on page 430. This section, I think, is critical, my lords. It says, on the hearing of any such application being a complaint to the disciplinary committee, the committee may, and I emphasize the following words, as it thinks just, make one or more of the following orders as to, and then there follow a whole series of orders, and the first of which is striking off the roll the name of attorney to whom the application relates. The appeal framework, my lords, if you go to section 16 on page 437, you see that an appeal lies to the Court of Appeal from a decision of the disciplinary committee by way of rehearing, and that the Court of Appeal under section 17 has the power to do various things, including to allow the appeal and set aside or vary the order of the disciplinary committee.
That's the norm, basically the normal appeal test, isn't it?
Yes, it is, I think. Yes, it is.
In this country, appeals from disciplinary decisions to the court are now by way of review only.
Oh.
But under the Jamaican legislation, it's a rehearing.
Regular appeal. Yes, yes, my lord. The General Legal Counsel, my lord, submits that to the extent that the Court of Appeal did so in this case, when I say did so, meaning to the extent that it set aside the striking off and varied it to replace it with a suspension and a mandatory continual legal education courses, it erred. This is an instance in which the Court of Appeal substituted its own view on penalty for that of the professional tribunal. So the question raised, my lords, is, was that warranted in this case?
Well, the first question is, what's the test for intervention, isn't it?
And
were they entitled to intervene?
And the answer to that, I would submit, my lords, is when the sanction is not just, it's not correct, or it's inappropriate.
Or if the council has made an error of principle in its approach?
Yes, but I think, well, I don't want to speak for my friends. I think we're agreed that there is, I think that the appeal is only in relation to sanction, so the professional misconduct part is not the subject of the finding of professional misconduct is not the subject of the appeal, as I understand it.
Yeah, but I think the question being put is, if there's an error of principle in the approach to sanction, is that not the basis for
of course, if there was an error of principle, and we're submitting there was none. So, because it's a general legal, and that's exactly where I was going to next. I was going to next to state that it is a general legal counsel submission that the intervention was not warranted in this case because there is nothing inappropriate, wrong, unjust, or any incorrect principle applied by the disciplinary committee when it ordered the striking off of the attorney. At the time of the proceedings, my lord, before the disciplinary committee, the attorney had been in practice for some 35 years. And he was practicing in the areas of criminal law, estate matters, conveyancing, personal injury, and actions seeking redress for the unlawful actions of state agents. That was his evidence given to the tribunal.
Is he back in practice now, as a matter of interest?
I don't know. I mean, I know
it's
that
5 years is
the 5
up,
years,
isn't it?
the 5 years has expired.
Yeah.
Lord, if I may say that I'd seen his new practicing certificate, which had effect from the 3rd of August last year.
Right.
Obliged to my friend. The Court of Appeal, my lords, expressed the view that the disciplinary committee's primary purposes could have been adequately met by a sufficiently lengthy period of suspension and the continuing legal professional development training. And that, they said, at EF page 80 in paragraph 41, sorry.
I'm sorry, which paragraph do you say?
41.
41, thank you.
It's in the middle of the page. I want to highlight the structure of the judgment rather than read it verbatim. I'm sure your lordships have read it.
We have.
But prior to paragraph 41, at paragraphs 37 through 39,
Well, their essential way into reviewing the sentence is that they said that the counsel had approached it on the basis that he'd been dishonest, but they hadn't made any finding that he'd dishonestly handled clients' money.
yes, and I will come to that too, my lord, because equally the disciplinary committee had not made any finding that he was not dishonest.
Well, I don't think it works that way around, does it? You're not presumed dishonest unless found honest.
No, but in this case, it wasn't really a matter of great relevance, and I will come to that.
Well, that may well be the key.
Yeah.
I'm surely that would have been highly relevant to the question of sanction, dishonesty or not.
Well, there are cases in which the sanction of striking off is imposed even where there is no dishonesty.
No, I understand that.
That's true, but that's a different point.
itself is one of those.
The question is, have they applied a test relating to dishonesty, but without making a finding of dishonesty?
Yes, but I think that in saying that the Court of Appeal, the Court of Appeal in saying that the disciplinary committee was to be presumed to have that the disciplinary committee was presumed to have been must be taken to have presumed that the attorney was handling his client's money dishonestly is I think not quite fair to the disciplinary committee.
Well, what's the relevance of saying that lots of attorneys have been struck off for dishonestly handling clients' money if you don't think that this is a case of dishonestly handling clients' money, or you're not approaching it on that basis?
Well, I think they were just quoting a section from the case.
Yeah, but then they comment on it and they emphasise the bit about dishonest. It's quoted at paragraph 36 of the Court of Appeal's judgment.
And we see it in context if we need it at page 53. Yeah. In the
they say that a lot of Jamaican attorneys have been struck from the roll for dishonestly handling monies. So the implication, obviously, is that that's relevant to their decision. It's not as though they then go on to say this is a case where, in fact, it wasn't dishonest handling, but for all the reasons we now give, we should nevertheless strike off. They launch straight into the sanction after that.
Well, I think when you look at the decision of the disciplinary committee, you see that there were some 58 findings that it made. And it said for all of these findings, it comes to the conclusion that there was
Well,
professional...
58 findings, most of them are just findings of fact, and not a single one of them mentions dishonesty or any similar word.
There is no express finding of dishonesty. I'm not here to challenge that there
But when
was...
you say express,
Yeah.
are you saying by implication there's a finding of dishonesty? Because that's problematic, isn't
No,
it?
I'm not
Yeah.
saying there was a
No, there's no finding of
There's-
dishonesty,
yes.
express or otherwise. There simply isn't a finding of dishonesty.
I just
There was an exploration of it because there was some criticism of the fact that Howard Wilson hadn't provided any explanation, and the attorney hadn't produced anything in writing or sufficient in writing from Howard Wilson. But ultimately, there's no finding that there was dishonesty.
That is so, my lady.
Well, it's very problematic, their reasoning, when immediately after the paragraph referring to people being struck off for dishonestly handling monies, they then go on to announce their sanction with no more explanation of why they think striking off's appropriate.
Well, my lords, I think when you look at you have to look at the decision of the disciplinary committee on page 39.
So,
The original decision, you mean?
Yes.
yes.
First of all, I'll have to look at paragraph 3 from the top, where it says when one weighs evidence given by the complainant and the facts that have to be proven in relation to the complaint, the panel finds that her evidence does indeed rise to the standard of proof required. The evidence of the attorney has failed to discredit or undermine the evidence of the complainant, and his evidence indeed supports her evidence in material particulars, the most important of which is that the complainant said that the attorney never paid over to her shares of the proceeds of the sale of 10 Fairborn Road. So the thing that is most important from the perspective of the General Legal Counsel, from the disciplinary committee, is that the attorney failed to pay over to his client, not just pay over, to account for and pay over to his client monies that he held in trust for her. And not only did he fail to do that, he took those monies and paid it to someone else without her authority. So when you look at the bottom of that page, you see there's no credible documentary evidence that the attorney did in fact send proceeds of sale to Mr. Howard Wilson. There is no letter from Mr. Wilson acknowledging receipt of any such sums. Telegraphic transfer exhibits were not clear and unequivocal that proceeds of sale had been sent to Mr. Howard Wilson. And it is interesting the language that they use in finding number 49. On page
Well, maybe they suspected that he pocketed a share of the money, but they didn't make any finding to that
They did not make, but as the language they use at 49 is interesting. The attorney breached his fiduciary duty to the complainant if, as he says, he paid over the money due to her brother Howard Wilson.
Well, you can't sentence him on the basis of suspicion. Yes. Either you find that he's pocketed some of the money, or he had some dishonest arrangement with Mr. Wilson, or you don't, and they didn't.
Yes, but I will be submitting, my lords, that even absent dishonesty, the remaining facts on this case warrant the attorney the striking off sanction being imposed on the attorney.
You clearly have a gross breach of fiduciary duty on the undisputed facts of this case. That is perfectly clear. But you cannot pray in aid what is said at the bottom of 39 and the top of 40 for us to infer a finding of dishonesty, because you've already conceded, I think, correctly, that there is no express or implied finding of dishonesty.
Yes. Yes, that is so.
In which case, while he may not have vouched the fact that he paid the money to Howard Wilson, we must presume that he did, because there's no finding of dishonesty.
And I'm saying that, my lord, even if he did, even if we operate on that presumption, that was something done
Yes.
with his client's money, without her consent or authority.
Oh, yes. I mean, the idea that he took the say-so of Howard Wilson to deprive his client of monies which he must have known were due to her is a gross breach of fiduciary duty.
And the question is striking off warranted in the face of this kind of gross breach? Sequentially, in its reasons, the Court of Appeal turned its attention to the protective mandate of the disciplinary committee only after it spoke to aspects affecting the attorney personally. So in pages and paragraphs 37 to 39 on EF page 79, I'm not reading them, but I'll just highlight some of the various aspects that the Court of Appeal emphasized. That there was no express finding in the strict sense or usual sense that he was dishonest, when we have just dealt with that. B, that the attorney was being treated as a first-time offender. C, his conduct was in the nature of professional naivety, bordering on gross negligence. D, there was speculation that his misconduct may have been due to lack of familiarity with the law and practice of conveyancing and probate and the interplay of those two areas.
Sorry, where are you reading from?
I'm
Paragraph 39.
synopsizing aspects of...
In the Court of Appeal's judgment.
That's it. Sorry, thank you.
Yes, but we don't know where this idea of naivety and unawareness of the practice of conveyancing and probate comes from. Was this counsel's submission? There's nothing to that effect in the findings of the disciplinary committee.
And in fact, the evidence was that the attorney was in practice for 35 years and doing probate and conveyancing.
Well, he sounds a pretty general practitioner.
Yeah.
Yes, but in his general practice over the course of more than 30 years was probate and conveyancing. These would not have been new areas for him.
Well,
unfortunately, there are some people who could be in practice for many years and they never learn some of the basic requirements.
Yes, but in any event, I was struck by the paragraph in the sense that I didn't see where in the findings of the disciplinary committee that there was a basis for a finding of naivety.
Well, presumably you say there's none.
You say it's speculation.
And we say there's none. We agree with that.
When you were speaking before, you said that it was the respondent's own evidence that he practiced in the area of conveyancing. Do you have a bundle reference?
Yes, I do have a reference for that. That's EF 314 to 315 in the transcript.
Thank you.
Thank you. Yes, the bulk of his practice was criminal.
If you look at the
But we
bottom,
do conveyance, personal injury, suits against the Attorney General. Yeah.
bottom of 314 to top of 315.
Yes, thank you.
State matters and conveyance. Yeah.
Was he talks about we, he's asked about the
Yes.
practice. Did he work with other people?
No, he did not, and that was an
just
issue
on
that
his
when you read the transcript, you see that the disciplinary committee keeps saying to him, you keep using the plural we, could you
Yes.
please say I? Yeah? I think it's a manner of speaking. And of
Well, he
course,
does suggest on page 315 he has other lawyers working for him.
yes, but not in, but he does
But not
make
in
it clear.
not in partnership
Yes,
with
he
him.
does make it clear that it's not in
Yeah,
partnership.
yeah.
And of course, the other factor which the Court of Appeal took into account before I go away from those is the fact that he made restitution. But it is important to note that the restitution was only made on the very day before the commencement of the mitigation hearing in respect of sanction.
It was part of the sanction, though, wasn't it? An orders to pay not only all the money that he should have paid over, but costs, compound interest, and
Yes.
other things as well. So that's part of the whole sanction that was imposed.
Yes, but even before the finding of professional misconduct and the imposition of the sanction, he had himself issued an agreement on the 30th of April 2014.
Yes, but I mean, he had a clear duty. If he didn't have the authority of his client to hand the half share of the proceeds to her brother, it didn't take a further agreement. He had a duty to pay that money to her.
He did, but he...
And your point is, he took years to make reparations.
Years to make reparations. He put that agreement in writing.
So just on that, I mean, I think if one takes it in stages, he had a clear duty right from the start to
Yes.
pay the money, and that's back in 2012, I think.
That's probably even
The
before
complaint is
2011.
brought-
I think the transaction closed in 2011. It is
2011, sorry.
It's the disciplinary proceedings that started in
I'm so sorry.
2012.
And then the complaint is brought, and in the face of that, he signs the document, I think, of the 30th of April 2014, saying, yes, I owe the money and I'll pay it back.
Yes,
And then I think your point is he doesn't even
honor that agreement.
honour that until 2017, just before the
Just
sanctions.
before this, after he's found guilty of professional, because 2014 precedes the conclusion of the disciplinary committee.
Right.
Yes. So
And it is on the very eve of the commencement of the mitigation of the proceedings in mitigation of
yes, I mean, clearly the disciplinary panel had to take account of the fact that there had been full restitution, but your point is that it was a severely delayed full
It was
restitution.
severely delayed, and that in and of itself was not sufficient to take him out of the bounds of where a striking off would have been appropriate. Since we mentioned that 30 April 2014 agreement, I just would ask your lordships to note the specific findings of the disciplinary committee on 41, EF page 41, at numbered items 42 and 43.
Sorry, just give me that page again.
EF 41,
Okay.
41, and numbered items 42 and 43 on.
Yes, I mean, there seemed to be some quibbling about whether or not this document was,
Yes.
had been signed, but the fact is you've got findings of fact that it had been.
It had been, and it was in fact raised by the Second Court of Appeal judgment, the one that gave us permission, very limited permission, to come here in relation to the two issues that we're here on. So my lords, so there are all these, the point I wanted to make was there are all these aspects that are personal to the attorney, that the Court of Appeal addresses its attention to in paragraphs 37 through 39, prior to coming to what should be the issues of primacy, which it addresses subsequently. It is as if the Court of Appeal was giving primacy to the factors personal to the attorney instead of to the protection of the public and the profession. The latter being what was the focus, the primary focus, and we say correctly, that was prioritized by the disciplinary committee. And if you look at EF 14, paragraph 3, right at the get-go of their Am I going too fast, Mellis? Page number 14.
They state that the primary objective is the protection of the public and the reputation of the profession.
Yes, yes. I was taking you to that paragraph.
Yes.
Third paragraph on that page. The panel is starting, the panel is mindful, and ending reputation of the legal profession.
What they don't seem to do in their decision on sanctions is to explain why it wouldn't have been adequate to impose a lesser sanction, such as a period of suspension, further education, full repayment, compound interest and costs.
Well, you do see when you come to the sanctions decision that their view is very clear, that the transgression is viewed by them as being very serious, extremely egregious, inexcusable.
I know they give all those descriptions of it, but they don't address the question of why it wouldn't be adequate to impose suspension and the other package that the Court of Appeal have.
Well,
I mean, before you impose the ultimate sanction, you ought to give a reason why nothing less will do.
well, I think that may be because in this case there was actually a substitution of suspension with striking off, then one would, in looking at it in reverse, you would be saying, why then did they not say suspension instead of striking off? But they were looking at it from their point of view of what did these transgressions amount to? What was the extent of the transgression? What is the appropriate sanction in the circumstances here? And I've not often seen that there needs to be an explanation of why not all the lesser sanctions before you get to the sanction that you think is appropriate. So I think that maybe because we're looking at it in hindsight, why that is, my lord. But
maybe there's a different practice in Jamaica from what's now become the practice in England, where you are expected to explain why it's proportionate to the sanction, which involves some indication of why a lesser sanction wouldn't be sufficient.
Well, there certainly is no binding obligation or requirement to do that in Jamaica. It is that you need to ensure that the sanction that you're imposing is just and correct, and in accordance with legal principle, that it is not aberrant or capricious or something else.
I suppose you could say in terms of local practice, the Court of Appeal, I don't think, criticised the GLC on the basis that they hadn't explained what lesser sanction,
Yes,
or that they considered a lesser sanction.
They did not. They just, their criticism was limited to, we think that that the sanction was inappropriate for being harsh.
It wasn't limited to that. It wasn't.
At 41, the Court of Appeal says that...
41 is not the Court of Appeal. You mean paragraph 14?
Yes, sorry, 41 on page 80 in the Court of Appeal. Mm-hmm. They say their desire to comply with the purpose of disciplinary tribunals discussed in Bolton could have been adequately met by a sufficiently lengthy period of suspension. In other words,
yes, that is in their view.
There is the proportionality question.
Yes, but when you look at Bolton itself, you see that
But the lead into the whole of this is that they think that the council have approached it on an erroneous basis in principle, which entitles them to relook at it because of their approaching it as if it were a question of dishonesty when there'd been no finding to that effect. And that seems to me the fundamental point that you have to grapple with, is why that didn't entitle the Court of Appeal to review the sanction, if it had been made on an invalid basis, imposed on an invalid basis.
Yes, and I'm trying to grapple with it in two ways, my lords. One is by saying that was a jump, that was a presumption that they made, and whilst in hindsight you can see that there may be some kind of factual basis for them to arrive at that presumption, it is not an inescapable conclusion from what the disciplinary committee said. So that's one way. And the other way is...
I'm so sorry, just so I can understand. When you say they made a presumption, are you now talking about the Court of Appeal or the disciplinary?
The Court of Appeal says the disciplinary committee must be presumed to have found that the attorney was acting dishonestly. When
Well, or to have approached it on that basis,
Yes.
yeah, even though they hadn't found it.
Yes, yes.
Right.
And I'm saying that's not an
You're saying
inescapable...
you needn't draw that inference.
You
from
need
what they
not draw that inference. That's one way of defending it. The other way is to say that, and the disciplinary committee was mindful of this too, even if there was no dishonesty, there was still sufficient egregious conduct on the part of the attorney that warranted the striking off. So those are two bases.
But if you get to the point where you think that there's been an error of principle, so that the Court of Appeal are deciding the case for themselves, at that point, can you say that the only possible sanction was erasure or strike off in this case? Or is it possible that the sanction might be one of suspension, in which case it's very difficult to see how we can interfere with the Court of Appeal's decision?
Once you get to the point where you are accepting that the disciplinary committee made an error of principle, then it is hard to keep the Court of Appeal out.
Right.
Yes.
Okay.
So I am totally with you on that.
Okay.
What I am saying is that the disciplinary committee did not err in principle, and so that is where I'd like to try and take you to, if I could.
Yes, the reason this case is being treated as one of general public importance is that guidance is sought as to the appropriate test for an intervention by a court in respect of a disciplinary panel's decision. Could I have very clearly, what is your submission as to the test? Is it the one that the Court of Appeal has stated at paragraph 30 on page 75? The intervention of the appellate court in matters of sentencing imposed by the disciplinary tribunal ought to be limited to cases where errors of law exist or where the sentence is demonstrated to be clearly inappropriate.
Yes.
Is that the test?
I wouldn't fall that test. That certainly falls within the test.
You're happy with that test?
Yes.
Thank you.
Because we're saying there were no errors of law and that the sentence was appropriate. But in further answer to your Lordship's question, there is also the test of whether the conclusions of the committee are supported by tenable reasons grounded in the evidence.
So that it must be adequately reasoned.
Adequately reasoned.
But this isn't a reason.
There would not be, it would not be unreasonable, and if it is not unreasonable, there is no basis for interference with it.
Yes, but there's no reasons challenge, as Lady Simler says here. You don't have to address a challenge based on the inadequacy of reasons as such. The challenge that you're facing is that there has been at least an implicit finding by the disciplinary committee of there has been a test of applied in relation to dishonesty, but no finding of dishonesty, I think, would be the appropriate way of
And I don't think it was so much of a well, I think it was dicta that they were quoting, as I said, not necessarily giving rise to that presumption. But And that, of course, Your Lordship has just highlighted the very two issues that we were given permission to come here on. Those two issues set out by the Court of Appeal, the test for when to intervene. It is submitted by the General Legal Counsel, my Lord, that to warrant the Court of Appeal's setting aside of the striking off, it must be that it was incapable of being a just sanction. And that also is also in part answer to Your Lordship's question about when is the threshold for intervening.
Yes.
Once it is just, once it is correct, once it is not wrong, once it is appropriate, there is no need to intervene.
But is that just a reformulation of the second part of the test set out by the Court of Appeal, paragraph 30?
Yes,
where the sentence is demonstrated to be clearly inappropriate. So there are two possibilities. One is whether you call it error of law or error of principle, and the other is, even in the absence of error of principle, the sentence is demonstrably inappropriate.
Yes.
I mean, the fact that the Court of Appeal disagrees is not a sufficient reason, because there may be cases in which there's more than one sentence which could be reasonably be arrived at without it being outside the permissible range.
Which is where...
And you say this is that case?
This is that case. And I want to go a little further, if I may, my lords, because I think there was... The Court of Appeal approach to the issue of appropriateness as being mutually exclusive with harsh. So if you look at EF page 69, at paragraph 18,
Yes.
and I'm looking at, say, about 5 lines from the bottom, lads, where it says, however, the approach that is recommended to be taken in this analysis, that is this analysis by the Court of Appeal, is to focus on the sanction of striking off itself in the circumstances of this case. It will either be found to be appropriate or harsh. Therefore, and so on and so forth. So they are drawing, the dichotomy there is between appropriate and harsh.
They should have said unduly harsh or something like that, probably.
And because, well, we are submitting that that approach is flawed, because that the sanction of striking off is harsh is inherent in an order striking off. It is possible for an order to be both harsh and appropriate. The function of the Court of Appeal was to determine whether, on the facts of this case, the striking off order came within the bounds of what was just. Many authorities, my lords, including Bolton, say that misconduct of the nature that occurred here would ordinarily merit a striking off. And if your lordships remember the facts of that, you would know that that was a case where the attorney was 2 years at the bar.
Is this, sorry, is paragraph 18 their conclusion, or is it part of the summary of what the argument was?
No, my lord.
Because it's saying the approach that it is recommended to be taken in this analysis, and they've been discussing what the council was arguing for.
Yes, I did not read it that way, my lords. I read it, when I read the whole thing, it appears to me, and there is
Well, this is a summary of the council submissions, though, and when it says it's recommended to be taken, that surely is saying what council is recommending the court to how they're recommending the court to approach it.
And the test they set out is
Paragraph 30.
under the heading discussion,
yes.
which starts at 27.
But the summary of the submissions follows that on the next page. It's not on that page.
No,
Well,
the
it's
summary
part
of
of the summary of
submissions, that's moving on to ground D, isn't it?
Oh, yes. That's right.
The hearing of the appeal, and then they summarise submissions on the sanction of striking off.
But 18 comes at the end of an account of how council had given up on the challenge to conviction and was focusing on sanctions, and reads to me at least as though it's part of what was being put, the approach that was being adopted by council.
No, certainly that was not my takeaway from either the submissions
But
that I was
in any event, I think you accept the test set out at paragraph 30 in the context of the discussion. Is that right?
Yes, my lord.
Yes.
That was the paragraph you had taken me to earlier, my lord.
Yes.
Yes. And the GLC submission, of course, is that it was just for the 58 reasons set out by the disciplinary committee, some of which are highlighted in paragraph 17 of the appellant's written case at EF 397. I'm not reading them. There are items 1 through 8 set out there. I know your lordships have read the written case already, so I'm just highlighting that. But, my lords, while you are there on that page, could you just, with your leave, I ask to be allowed to add the following words at the end of paragraph 15.
Yes.
And thereby inappropriate. So that
Harsh and thereby inappropriate.
Yes, so that paragraph 15 would end. The sanction of striking off was harsh and thereby inappropriate.
So it's really, you're saying unduly harsh. Because you're accepting, I think, in your submission
Yes.
that striking off can be harsh, but still appropriate.
It's always harsh.
Yes.
For a lawyer, striking off is always harsh. There's no case when it's not harsh.
Should we, to summarise your submission accurately, say, add the words unduly before harsh and thereby inappropriate? That seems to be consistent with what you're wanting us to
Yes, well,
understand.
that's almost an alternative to and thereby inappropriate. Because unduly harsh would be inappropriate, whereas harsh is not.
Harsh is not
It's not
necessarily.
necessarily inappropriate. It's 6 of one, half dozen of the other. Yeah.
Thank you. Thank you.
You probably want us to say clearly inappropriate as well, I think.
Yes, you can. Any number of ways, my lord.
Well, certainly, if you're accepting paragraph 30 test, that would be the wording. Yeah.
When we talk about inappropriate, I mean, that's one of those words it's often not very easy to understand what is being conveyed by it. The statutory word is just. You took us to section 12.4.
What is
Should it
just?
not be and thereby unjust? And then we have to unpick what unjust means. I can't really see the point of substituting a new word for the statutory test.
And my lord, the only reason why I was using appropriate and inappropriate was because that was a terminology used by the Court of Appeal.
Yes, well, I'm just questioning whether it's actually a helpful
It's not
word
helpful.
to use.
I would submit it's not helpful. I would submit just is the more helpful term.
I would have thought that what clearly inappropriate is getting at, whether you use that or you call it manifestly excessive or something like that, is the idea that there may be a range of permissible sentences and it has to be outside that.
Yes.
Well, I suppose
It's not
clearly,
just an on-off question.
And
I suppose
in that sense,
clearly disproportionate.
Yes, something like that.
Because inappropriate tells you nothing
Tells you
about what you're trying to grapple with.
tells you nothing.
Whereas disproportionate actually does address
Yes.
a relevant factor.
Yes.
Or excessive.
Yes.
Excessive and disproportionate.
All of which lead to the destination. All of which lead to the destination of unjust.
Well, the Gauche test is the sentence appropriate and necessary in the public interest, or is it excessive and disproportionate?
Yes.
That seems to me to convey.
That's doctors'
Yeah,
counsel.
yeah.
In this case, my lords, the attorney took the complainant's money, failed to account her for it, and then gave her money to someone else without her authority. From his client's perspective, it made little difference if he kept her money for himself or if he gave it to someone else. The point is that he didn't account to or hand it over to her. I showed you before where the disciplinary committee was very alive to this. And in further connection with that, I would like to emphasize the following findings of the disciplinary committee, if I may, my lords, at page EF 40 to 41. I wish if you could like circle finding 28, finding 39,
28,
28,
39,
39, 46, 48, and 49.
Just repeat those. 28.
39,
Yeah.
46,
Yeah.
48,
Thank you.
and 49.
Thank you.
And
well, that was the essence of her complaint, which they've upheld.
Yes.
yes, and which they're and not only and upheld not just on an if and but basis, but upheld on the basis that the evidence adduced by the attorney and the documents before them corroborated the complaint of Olive Blake.
Well, he admitted it, in fact, didn't he, in his evidence? They didn't even have to rely on it. He actually made admissions.
He did make admissions.
Yes, and I mean, there are further findings which I don't think ultimately they relied on about an illegal state agency charge, an illegal deduction, a premature conferring of title, which suggest a level of incompetence. But,
Yes, but
ultimately the focus of the disciplinary committee was on the lady's complaint.
Yes, my lord. But I don't want to be seen as being too quick to say that I don't think those findings were relevant, because I do think, because if you look at 43, I'm sorry, my lady, I'll come back to you in just a second if I could just answer the chairman. At the very top paragraph on page 43, where it says conclusions, the panel concludes that based on the evidence, oral and documentary, and on its findings, the attorney is to a standard of proof beyond a reasonable doubt in breach of canon, so and so. So it's not limited. It expressly links the finding of professional misconduct to its findings, as well as the documentary and oral evidence that was before them. And there are two places in the disciplinary committee. Oh, sorry, my lady.
No, carry on.
There are two places in the disciplinary committee's reasons where they make that point about the force of the evidential material before them. I would ask you to look at EF page 39, paragraph 3.
That's the one you've taken us.
Yes, I took it to that already, and that is repeated at EF page 40 at the top, starting the second paragraph that starts in examining the substance. Do you see that, my lords?
Well, Well, it did, but if you look on page 39, fourth paragraph down, the attorney admits he did not pay any of proceeds of sale to the complainant, so they don't have to strive too hard to reach that conclusion.
No, they certainly did not.
I mean, on the face of it, it was a gross breach of fiduciary duty, but there's only so many times you can make that point.
Yes.
One of the points that I was just going to, one of the points that Olive Blake made in her evidence was that a lot of these letters were forged, that they weren't, the letter didn't reflect her own signature, it didn't reflect Howard Wilson's signature, but that was not accepted by the disciplinary committee.
It was not.
They made no findings.
They made no findings on that, and that was, they said they were not doing so because that was not a part of the complaint.
So he admitted those aspects that constituted the gross misconduct charge.
Yes.
He denied all the other aspects, and they did not find against him on those aspects. But on the aspects that supported the gross misconduct charge, he admitted.
Which he admitted, striking off was an appropriate remedy.
Well, can we return, please? You referred us to page 43 and the conclusion. The panel concludes that based on the evidence, oral and documentary, and on its findings, the attorney is in breach of Canon 7B1.
Yes.
And I think we find Canon 7B1 on page 476, which is that the attorney must keep such accounts as shall clearly and accurately distinguish the financial position between himself and his client. So there is a crescendo and then a rather understated conclusion that there has been inadequate accounting.
Yes, he has not only, well, if you look at the statement of account that he rendered, it's not even addressed to Olive Blake. It is only addressed to Howard Wilson. So he has not even provided her with a statement of account.
Well, hold on, is it a mistake? Because they talk about the law applicable at the bottom of 42. Yes. The law applicable is that he shall account to his client for all monies. That's what they're finding.
Where are you, my lady?
Sorry, bottom of page 42. EF page 42.
Yes.
After they've made 58 findings of fact.
Yes.
The law applicable is clause 7B2, which is the failure to account, rather than the keeping accounts separately.
I know, but then over the page they find a breach of...
Well, I'm wondering whether that's a mistake.
That may be a typo.
I don't think it is, because he was keeping a record in an exercise book, wholly inadequate, completely failed to disclose his internal records of what had happened with this money. So I think both subparagraphs are relevant. I mean, clearly the most serious thing was not to pay money to his client, which was hers, and which he owed her a fiduciary duty to pay.
But
I mean, this is all quite confusing because on page 43 in the second paragraph, the panel says the attorney is therefore guilty of professional misconduct in that he has failed to pay over to the complainant her share. So I think it goes back really to that being the complaint.
And actually that's the charge that's in the charge sheet.
And that is Canon 7.2, account to his client.
B2, it's B2.
Yes.
It's B1 and B2.
Well, B2 is in the charge rather than B1, but...
So there must be a typographic error.
I think it's a typo. Typo. It should be 2. And there is more than one typo, so...
Yes. That would have
to be a
explanation.
Yes.
I was slightly puzzled by the finding.
I mean, it's almost certainly true that the evidence would have justified that other charge, but it is on any footing the lesser of the two charges.
Yes.
Not failing to keep proper accounts is obviously a serious matter. Failing to pay to your client what is due to her is a very serious matter.
Very serious matter.
Yes.
Upon being reasonably required to do so. Don't forget those last words.
Yes.
Because she did require him to do so.
And he acknowledged his liability to do so in writing in 2014.
Yes.
But it took him another 3 years to do it.
Yes. And when she tried to when she decided to bring legal proceedings to force him to pay her what was her money that he was holding for her, he referred to her as being a wicked and evil devil for doing that, and that is on EF page 244. So the circumstances of this case show an experienced attorney of over 30 years in practice who, when confronted with registering the property in the name of the purchaser before securing the full proceeds of sale, responded to say he doesn't practice with that rigidity being having to observe the conditions of the agreement for sale. And that evidence, should you wish to see it, is at EF page 354. But in addition to that, that particular complaint, that particular fine is two express findings of the disciplinary committee, findings number 55 and 56 on EF page 42. You see
Sorry,
those?
you took us, sorry, to page 354. What was it you wanted us to see?
It was an answer he gave in cross-examination, was it?
Yes, 354 is the evidence of the statement that I just...
Sorry, where is it? I've got 354 up. I'm just trying to...
354.
Well, the one thing we're not doing here is retrying the case, deciding what we think we...
Can we just see, just tell us what you're referring to?
In the middle of that page, my lord.
Which answer?
I don't know, I never practiced so rigid, I think.
I
Is that
see.
it? I don't know if a man buying a place for
He was being confronted with
All
the
right,
fact...
okay, well, that was his evidence. That's what he said
Yes.
there. But is that reflected
In the finding.
in the finding?
Yes, and I'm saying, and that was where I was taking you to next.
Okay, where is it reflected?
On page 42,
Yes.
findings 55 and 56.
Tenant secured the registration of the name of the purchaser. This was in breach. Sorry, I don't think it is reflected in 55 and 56, is it?
Yes, because the question was being asked in the context of, you have let the purchaser into possession in breach of the terms of the agreement for sale without having first secured the purchase money.
Oh, I see.
And so
The point was he accepted he was so cavalier, he wasn't rigid enough to actually require the price to be paid before he registered the title.
I follow you now.
Exactly.
Yes.
Exactly.
Yes.
Yes?
Yes, well, I mean, I mentioned that as one of the things, a premature conferring of title was what I referred you to,
Right.
and this is the evidence.
And that is in addition to knowingly holding the complainant's money on trust for her, which your lordship has pointed out that he admitted that he held her money on trust for her, and he said he knew that he held it on trust for her, and then failing to pay it over to her when required to do so.
But you say that's in addition, but I thought we'd looked at the charge against him, which was under Canon 7B2,
Yes.
which is essentially failing to account for monies in the hands of the attorney for her accounts.
You're looking at why it was that he came to be failing to hand over the money.
I mean, there are no findings that he failed to hand over the money because he prematurely conferred title. I mean, his case was that he accepted the brother's account, that the money was due to the brother, and that he gave the money to the brother.
Yes, this is all the background facts that the General Legal Counsel was looking at the evidence.
But you're not asking us to impose our own view on this, are you?
No, I'm not asking you to impose your own view on it, my lord, because I see no defect in the view taken by the...
No, so the question is, was the Court of Appeal entitled to interfere? And if the council approached it on a wrong principle, they were, and if they didn't, they didn't.
Very simple point. Very simple point. The failings, in other words, my lords, so the failings of the attorney constitute a clear and present danger to the public and the maintenance of the reputation of the profession. The dicta of the disciplinary committee from Bolton that is quoted by them on EF page 53, I think is relevant because of its parallel, almost, it mimics the circumstances of this case.
Is it relevant to what we should do that there was no stay of execution of the Court of Appeal's order and it's now been fulfilled? And if we were to reinstate the order of the council, we'd be taking him out of practice when he's actually been practicing now for a year or so.
But the fact that he's practicing now is advantageous to him. That's not something that's going to affect him.
You say that's irrelevant?
He has had longer to practice than he would have had if he had been struck off, if the striking off order had been maintained.
But your point is that you say on the findings of the breach of the canon, looking at the circumstances set out in the findings, he is a clear and present danger to the public.
Yes.
And you were referring us to something on page 53. 53
at the top, the first paragraph, which is really, it starts out as a quote from Bolton, where it says, in most cases, the order of the tribunal will be primarily directed to one or other or both of two purposes. One is to be sure that the offender does not have the opportunity to repeat the offense. The second purpose is the most fundamental of all, to maintain the reputation of the solicitor's profession as one in which every member of whatever standing may be trusted to the ends of the earth. To maintain this reputation and sustain public confidence in the integrity of the profession, it is often necessary that those guilty of serious lapses are not only expelled but denied readmission. If a member of the public sells his house, very often his largest asset, and entrusts the proceeds to his solicitor pending reinvestment in another house, he's ordinarily entitled to expect the solicitor will be a person whose trustworthiness is not and never has been seriously in question. Otherwise, the whole profession and the public is injured. A profession's most valuable asset is its collective reputation and the confidence which it inspires. That's a quote from Bolton. And that's precisely what happened here. So I'm using that to show that it cannot be that the striking off is unjust. And in Bolton, in those circumstances which are not dissimilar to these, it was pointed out that the court was unwittingly doing exactly what authority said it should not do, which was namely substituting its own view on the penalty for that of the professional tribunal. And that is in Bolton at EF 552, second half of letter F. I'll just give you that reference. So coming to a rapid conclusion, my lords, in this case where the attorney's conduct was considered by both courts below to be wholly unacceptable and a flagrant departure from acceptable professional standards, that's a quote from the Court of Appeal, and quoting from the disciplinary committee, very serious, extremely egregious, inexcusable, and unacceptable, end quote. The striking off order cannot reasonably be regarded as wrong and or unjustified. Do your lordships want references to those quotes, page references to those quotes?
I remember them, thank you.
Okay. Did you say yes, Mother? Oh, okay, sorry. Of course, Bolton is, we would submit, very much still good law. This court applied it in 2019 in the case of Lane and the Attorney General for Grenada, which we all know is a case of...
what case is this?
This court applied it in Lane and the Attorney General from Grenada. That was an admission to the bar case.
Yes, well, I think we should probably look at that. I mean, if you remember, this case is before us because you are wanting confirmation or at least guidance as to what the appropriate test is for the
intervention
of the Court of Appeal rather than the particular circumstances of Mr. Lorne. Can you take us to the passage in Lane on which you are relying?
Well, it turns out that you don't actually challenge what the Court of Appeal says.
I'm only using Lane to show, my lords, that this court applied Bolton in 2019. It was a different kind of case because it was a case where the Privy Council was considering whether or not somebody should be denied entry onto the road, not a question of.
No, I appreciate that, but
where is it? Where's Bolton referred to?
Yes, I mean, what has Lady Arden, in giving the judgment of the board, said about Bolton that you want us to look at?
It is 565, paragraph 42.
Thank you.
But also interesting, my lads, the Apex Court in Canada in 2003, in the case of Law Society.
Let's pause for a second. I mean, Lady Arden is referring to Bolton for the proposition that the Supreme Court is also required by the good character condition to consider the question of whether the public can reasonably be expected to have confidence in the admission of the candidate. That follows from Bolton, where Sir Thomas Bingham emphasised the need to maintain a well-founded confidence in their solicitor. It's telling us nothing about the appropriate test at all.
Yes,
so Lane doesn't help us.
No, my reference to Lane is not in. Well, as I said, it was just to show your lordships that Bolton is being applied in 2019. I wasn't going to make.
But it's only being applied for the particular purpose, which is I imagine, unquestionable. That there is a need to maintain the public confidence in the legal profession. I'm certainly puzzled because if you accept that paragraph 30 of the Court of Appeal is the correct test,
it's not clear why you're here at all.
It's not clear what the point of general public importance is in this case.
Well, I hesitate to refer to judgments of a lower level than this court, but there is an English Court of Appeal case in Law Society and Salisbury.
Yes, and in paragraph 30, I think, sets out a test there.
Their lordships have that. So I wanted to go on to make the point that somewhat interestingly, the Apex Court in Canada, which takes the view of whether it is by way of judicial review, because my Lord Leggett indicated to me that in this jurisdiction now it's by way of judicial review, whereas...
No, sorry, it's not judicial review, it's actually a different sort of intermediate test. It's a review, it's an appellate review.
Okay. Well, sorry.
As opposed to a rehearing.
That's the point.
Oh, okay.
Rehearing.
Yeah.
Okay. And of course, even though the word rehearing is used, it has to be a review because you're not taking witnesses for the first time, you're not taking viva voce evidence, you're looking at the matters that were at least...
So it may not amount to any real difference.
Doesn't make any real difference, and that's one of the points.
I mean, can I just interrupt to say that the position in England depends on the relevant profession, I think. So I think my Lord is quite right as regards solicitors, but I think as regards doctors, the relevant legislation says it's an appeal by way of rehearing. Yeah. So I think it depends on the profession.
Yeah. I was talking about lawyers, sorry, barristers and solicitors.
Yes, but quite what difference that makes, I'm not sure.
I mean, I think sometimes in terms of English practice, the difference between rehearing and review, which is a product of the civil procedure rules, is sometimes difficult to identify.
Blurred.
Yes.
Yes, blurry. Yes, my lords, I agree. But I wanted to mention, as a matter of interest to your lordships, you probably are aware of it, that the Apex Court in Canada, Supreme Court of Canada, in 2003, in interesting and I thought useful judgment of the Law Society of New Brunswick versus Ryan, which is at tab 14, which starts at EF page 579. It supports the view that there should only be an interference with the decision of the committee where the conclusions of the committee are not supported by tenable reasons grounded in the evidence. And it certainly is a submission of the General Legal Counsel in this case. Let me give you a page reference for that.
I'm not sure what relevance it is unless you're suggesting that it's authority for the standard that we ought to endorse.
Unless what, my lord, I didn't hear you.
Well, I mean, are you... I thought you'd stated the standard that you were accepting was the appropriate one we should endorse, and if this says something slightly different, I'm not quite sure what its relevance is.
Well, I am not seeing it as different. I'm seeing it as
another way of saying the same thing.
I'm seeing it as another way of saying the same thing. That is how I'm seeing it, as another way of saying the same thing. And the page reference I wanted to give you was EF 597, letters A to B. So, my lords, for all those reasons, it is submitted that the striking off order imposed by the disciplinary committee was appropriate on the facts of this case, because I wanted to mention, too, that it's important that every case is looked at on its own particular circumstances. The authorities make that very clear, that there's no one-size-fits-all. Everything has to be looked at in its own particular circumstances. And submitting that it was appropriate on the facts of this case, and that being so, the Court of Appeal therefore erred by not according to the disciplinary committee the deference it should have on these facts in this case. And so for those reasons, my lords, we ask that you allow the appeal of the General Legal Counsel and restore the decision of the disciplinary committee, unless I can give any further assistance to your lordships. Those will be the submissions on behalf of the disciplinary committee.
Can I just clarify one point? That in the statement of facts and issues, at the end, the issues are stated. See, there's a statement of issues there.
Yes.
If one compares that with the decision of the Court of Appeal giving leave to appeal, that seems to be a slightly truncated form of the issues stated by the Court of Appeal, which is at the end, in the hard copy bundle, it's tab 11, yes. Page 115.
Yes.
I mean,
I was trying to synopsize it.
It was, but the Court of Appeal's order of the issues to come to the board is as set out in the order. It's said to be an order of Justice of Appeal,
yes,
McDonnell Bishop. Those are the issues.
And that order, yes, and yes, that order is to be found at, in fact, you had taken us to 115, but the actual formal order, my lord, yes, is to be found at 119, I believe.
119, right. We haven't got that in the bundle here, but it will.
Is it?
It's in the same terms, is it?
It's in the same terms, my lady, but it's just easier.
Sorry, 119.
117, sorry. 117. 117.
Right.
And this is of the Second Court of Appeal.
Right.
Giving permission.
Yes, all right.
And at the bottom of 117, you see the first order at A.
Yes, well, I think
It's in
maybe
the same terms, is it not?
it's in the same terms as on 115.
Yes.
But it's been summarised in the statement of facts and
It's been summarized in the statement of facts and issues, and because I think it all boils down to whether at the end of the day the sanction of striking off imposed by the disciplinary committee can be considered to be just.
What's
on the facts of this case.
What's on 117 is the same as
it gets.
Paragraph 11 that you say was a summary.
Sorry, no, it's, so 117 is the same as what is on 115.
Yes. Which is in our paper
Which is in
bundle.
our paper bundle.
Yeah.
Yes.
Which is slightly different.
Which is more expansive than what has been put in the statement of facts and issues,
Yes,
and
because-
wrongly described as being
Yes,
as
right.
framed by the Court of Appeal.
Oh, well,
I think it's better to have the issues
the exact,
Exactly.
I am guided, my lord. I think in the
Yes.
paying
Anyway, there we
attention
are.
to the practice
But
direction
those are the questions
regarding
we've been
brevity.
asked.
But yes, what we ask you to look at is the two issues as framed by the Court of Appeal, and nothing was meant by that. If you hope your lordship doesn't take askance upon that, it was an attempt to keep it short.
I understand.
Yes. So unless I can have any further assistance, my lords.
Yes, I mean, if you look at 107,
107.
yes, in paragraph 45 of the Court of Appeal's decision to give permission to appeal to us, they say that the question whether the striking off sanction opposed in the circumstances of this case, reading short, was clearly inappropriate, is a controversial one and of great general and public importance. I had understood that what they were seeking was that we consider the appropriate appellate test, but it may be that is not right.
I think
Well, that's certainly raised by the second question anyway, isn't it?
I think your lordship is correct. I think that is what they were trying to get at.
Yes. Thank you. Any further questions? No. Thank you very much. Mr. Maylands.
My lords, the two questions asked by the Court of Appeal, which I do have at page 115 in the bundle, can be shortly answered, but the short answer which we, for Mr. Lorne, submit is not helpful, particularly to the Court of Appeal below. The short answer to question A is that the intervention of the Court of Appeal was warranted, and the answer to B is no. And one would add that in dealing with A and B, that one should be very careful with the use of the word defer, because that's not what is in the latest authorities, and strictly speaking, defer means yield or obey, and there is no warrant for that approach by the Court of Appeal to the decision of the disciplinary committee.
Yield is not really what's being referred to. What's being referred to is, according the specialist disciplinary tribunal, some deference in the sense of recognising their expertise in disciplinary matters. That's what...
And the lady's absolutely right. The usage of the word defer in that context is plainly what level of respect should be accorded by the Court of Appeal to the disciplinary committee's findings. And what the Court of Appeal here is asking the board in these questions is, practically speaking, how do we correctly direct ourselves on the question of the place in our thinking in this kind of appeal that is enjoyed by the fact that there has been a consideration by a professional body. What is its place in the analysis which, on appeal, the Court of Appeal will apply? The starting point for the answer to that issue, your lordships have already been referred to, namely Section 16 and 17 of the Legal Profession Act, which we looked at earlier. I draw attention, without taking you back to those sections, that expressly there's no stay. In one of the authorities, and I think my Lord Leggett raised this, where a stay was possible, there had been a stay. It was the case of Bolton, and that put the Master of the Rolls, Lord Bingham, into a difficulty where he and the court wholly thought the Law Society were right, but could not allow the appeal because the consequence of that would be to put him back in a suspension when he had not actually been debarred from practice. But I'll come back to that. But there is one section, apart from the right of appeal and the Court of Appeal's rehearing powers in Section 16 and 17, which your lordships were referred to briefly, but the implication of it perhaps was not expressed. And that is Section 11 of the Legal Profession Act at page 428, which sets out who is to be appointed by the council to the disciplinary committee. And that says, the council shall appoint from among persons, B, who hold or have held high judicial office, a disciplinary committee. Now, the implication of the submission, which is made in the appellant's case, is that were this Court of Appeal on its retirement to go next week to become a disciplinary committee, it would, by that very fact, have an enhanced ability to judge appropriate findings and sentencing in a solicitor's or attorney's disciplinary case than it had enjoyed the week before. That, we submit, when they were sitting in the Court of Appeal, that, we submit, is a wholly unmaintainable submission. Now, the Lords, on...
well, it's not like a case of doctors where there is some expertise the court doesn't have. The reason is that a primary decision maker is given the responsibility, and it can't be enough of a reason to overturn that you disagree with them, because otherwise it would defeat the whole point, and you go straight to the Court of Appeal.
Yes.
So there has to be a range of views accommodated.
Exactly. So coming back to the essential task, which is to identify the appropriate place in the thinking of the Court of Appeal on appeal, occupied by the decision of the disciplinary committee, I just draw your lordship's attention to the modern authorities, which I'll come to here, have in the light of the Article 6 of the European Convention, that is to say, the fair hearing, fair trial provision, have, as it were, emphasized the importance of the appeal being a full appeal and a rehearing. And the Jamaican Charter does exactly the same. I'll give your lordships the reference. At clause 16.2 on page 542 in the electronic bundle, the protection of right to due process at 16.2, page 542, has, practically speaking, the same wording as imposing a constitutional right of a fair trial. So, the Lords, the respondent's first submission, obviously, is that the Court of Appeal exercised properly its appellate function and decided that the proportionate sanction was 5 years suspension, and it follows that the Court of Appeal must have thought that a lifetime disbarment was disproportionate, or in the language posed in the question 2A on page 115, the Court of Appeal thought that the sentence was inappropriate or unnecessary in the public interest or disproportionate, and that 5 years was sufficient to meet the public confidence in the profession test. Now, that is not tinkering. Plainly, it is not for the Court of Appeal, on appeal from the disciplinary committee, to tinker. But that isn't tinkering. That is taking a wholly different view of what was sufficient and proportionate to meet the obligations. And the Court of Appeal's approach, as your lordships have seen, is at paragraph 41 on page 80 in the bundle.
Don't you need to start earlier?
Yes, I have got a note to take you back. We do need to start earlier. The as it were, I won't read it again. The summary is at paragraph 41 on page 80. But the court has gone through a number of authorities, and on page 75, in a sentence, is what they directed themselves to apply. At 30 on page 75, accordingly, the intervention of the appellate court in matters of sentencing imposed by the disciplinary tribunal ought to be limited to cases where errors of law exist or where the sentence is demonstrated to be clearly inappropriate. Now, in the authorities, one comes to the most recent, where I submit there is a passage which is the complete answer to the Court of Appeal's questions. The word clearly is rather lost, because it is difficult to imagine counsel for the disciplinary committee in the Court of Appeal conceding that it was inappropriate, but asserting that it was not clearly inappropriate. That clearly, you either see that it is inappropriate, or you don't. There isn't a kind of mixture of seeing.
It's a bit like manifestly excessive, though. It's trying to convey the idea that disagreement isn't sufficient. Yeah. It has to be something more than mere disagreement.
Absolutely, my lord. But inappropriate, once you're into inappropriate...
Well, I mean, do you accept the paragraph 30 test as the appropriate test?
With my lord's qualification, as it were, to the effect of clearly.
Yes, well, I mean, this is a debate that often happens in the legal world about the use of adverbs.
Yes.
You could say exactly the same about manifestly excessive. If you concede that it's excessive, why do you need the word manifest?
Yes,
it's a warning to the appellate court.
Not to tinker.
Not to substitute.
Yes, not to substitute.
Tinker, and you could say, if the court was looking at it for the first time, they thought the appropriate sentence was X, and therefore Y was inappropriate. It's really a warning to the Court of Appeal not to put its tanks on the lawn unless something is very clearly wrong.
No, I come away from the word clearly altogether. But dealing then, so that's the test here, and this is a sentence appeal, and there are a number of features which were obviously before the Court of Appeal and which influenced their view. The appellant was born on the 22nd of March of 1953. He was suspended by the Court of Appeal for 5 years from the 24th of June 2017, and at that date he was 64, and 5 years when you're 64 is a rather higher proportion of your professional life than if it had been imposed rather earlier. Secondly,
it's a rather high proportion of his future professional life.
It is a higher proportion of his future professional life. So that's to be borne in mind. Secondly, he has undertaken successfully the re-education courses, and it mustn't be overlooked that the Court of Appeal did impose further credits that he had to obtain successfully by attending the appropriate courses, in addition to the annual ones, which are compulsory for everybody. And he did go back into practice, as I said earlier, on the 3rd of August last year, which was a feature of the Bolton appeal. Now, as it's a case that was heavily relied upon below, it begins at page 545 in the electronic bundle. Now, it's always, with these cases, very important to actually have an outline of what happened. In Bolton, the first decision was of a suspension of 2 years. In the divisional court, he was fined.
What had he done in Bolton?
Oh, right. He got a whole lot of money in, which he had should have disposed appropriately, and instead I'll show you the exact sentence, which shows that it was a very bad case. If you look at page 547, the Master of the Rolls sets out a little bit of background. It's a sale case, and then just above F, he did not do that. That is dispersed correctly. having received the cheque on 10th May, he started as early as 16th May dispersing that money. In just over a month, he dispersed the whole sum, partly to mortgagees and partly to the Inland Revenue, and that's to 25,000 to his wife. So,
the mortgagees, his own mortgagees, or somebody else's?
That's not entirely clear, but I think so.
Yeah.
So one can go straight to the fact that he gave 25,000 to his wife and say that
She was the vendor. Mrs. Bolton agreed to sell the lower ground floor flat. She was the vendor. Mrs. Bolton.
Yes.
Yes, right.
So
there was no finding of dishonesty.
No, absolutely not. There was no finding of dishonesty, but it was a 2-year suspension.
Yeah.
The Divisional Court reduced it to a fine, and the Court of Appeal thought that was undoubtedly wrong, but, and one sees that at 552, just below F. In my judgment, the Divisional Court was doing, no doubt unwittingly, exactly what authority says the court should not do, namely substitute its own view on penalty for that of the professional tribunal. And then the court, Lord Justice Rose and Lord Justice Waite agreeing, went to restore the original decision. But over the page, one comes to or just at the bottom of the page, one sees the problem just below H. In the present circumstances, however, a real question arises as to what should be done now, having regard to the lapse of time, and then the Master of the Rolls deals with that, and which had the effect of making it oppressive to reinstate the tribunal's order 2.5 years after the order was made, because he continued in practice, because it had been stayed. And then my Lord says, the Law Society acknowledge the force of this contention and are more concerned in this appeal to allay misunderstanding and obtain a clear statement of practice and principle than to achieve the suspension of Mr. Bolton from practice. And then various solutions to the problem were considered but rejected. And finally, the court says, just below B, I would therefore dismiss the Law Society's appeal, making clear that, in my opinion, on the quite exceptional facts of this case, well, they are that exceptional in the sense the exceptional fact is the complete abandonment of suspension and the substitution of a fine. But here there is a suspension, albeit not life.
But, sorry, I thought there was a complete striking out by the GLC here.
Yes, there was. That's what I'm saying. There was indeed. In Bolton, there was a suspension for 2 years.
By the disciplinary committee.
By the disciplinary
I rather thought the point being made was, since the Mr. Bolton was not going to be struck off completely, it was separately unfair for there to be this sort of stop-go situation in relation to him.
That's all it's saying.
But in our case,
there hasn't been.
The stop-go doesn't arise if the JLC's decision is upheld.
But one way of reading this is that you had the 2-year suspension by the Law Society, substituted for that a fine by the Divisional Court. That is a huge change.
Yeah, and he goes back into practice, presumably.
Yes, and he goes, because there are stays, no, because the matter was stayed pending appeal. So I don't think in Bolton he ever stopped practicing. Now, that feature is certainly exceptional because here the statute says there's no suspension pending appeal.
But what are you saying in terms of the principle to be applied here? Because it seems to me we're in a very different...
No, all I'm pointing out...
I thought you were saying that it would be, the analogy is that it would be oppressive a long way down the track to put in a more severe order, even though it would have been, even if it would have been appropriate to do so sooner.
Well, exactly, my lord. And he was suspended.
Right.
He was suspended. Bolton, he wasn't.
But your primary case surely is that the Court of Appeal were right to identify.
Oh, absolutely,
error.
yes.
Oh, okay.
Absolutely.
Yeah.
But sorry, just if you are making the submission that it's oppressive, it would be oppressive for us now to restore the order of the GLC. I rather question that. I mean, if the appropriate order was that there be a complete striking out, and we say that due to deference or otherwise, that is the appropriate order, what's oppressive about giving that order effect?
In Bolton, there was a 2-year suspension. That's not a difference in principle. He's suspended. But he's not in practice suspended. He practices continuously for a very long time subsequently. If the Court of Appeal was going to reimpose, as it were, uphold entirely the disciplinary committee's suspension and reverse the fine given in the divisional court, then all I'm pointing out is one feature of whether to actually do that, which Lord Bingham considered, Sir Thomas Bingham as he was then, considered relevant, was the fact that he'd been in practice since. So I'm doing a list of features in the case helpful on sentence generally.
But one can see that it would be unfair if the ruling against someone is not to disqualify them for life from practice, but for a set period of time. That order is set aside by the divisional court, so the person then takes steps to re-establish their practice, and they've done so to some degree. For the Court of Appeal then to step in subsequently and reimpose a period of suspension, because getting your practice up after one period of suspension is one thing. It is more oppressive to have to do that twice. But that's not our case, because...
No, it is more oppressive to have to do that twice, but it is a feature of, I won't use the strong word oppression, it is a feature of consideration that he has gone back into practice. He has served his 5 years, and he's undertaken his re-education courses.
But that point arises really right at the end of your submission.
It does. I'm just...
If we were against it on everything else,
so that,
we would allow the appeal,
I quite
we
agree.
would say that we nevertheless shouldn't, on the
I quite agree.
reinstate the order.
Turning now to the more general and, it might be thought, more difficult question, dealing with the place, putting it neutrally, of a decision of the disciplinary committee in the thinking on appeal. The Court of Appeal, I will give your lordships the references, and then I'll come to what our essential submission is, that they considered the case of Bolton at paragraph 20 on page 70 and following. Bolton was the case we just looked at. They considered a case called Langford, and then they considered, we submit very appropriately, the case of Salisbury, which is worth looking at, And then they came to their view in paragraph 33 on page 76. At the bottom, on page 76, at the end of paragraph 32, having reviewed the authorities, the Court of Appeal says, so that while we give all due respect and consideration to the decisions of the very experienced panel in this case, we are yet duty-bound to review all the circumstances to see whether it was fair and just for the ultimate sanction of striking off the role to have been imposed. In our submission, that simply can't be criticised. That's what they should be doing, and it's what, having reviewed the authorities, they actually did.
It slightly sort of groups together two separate things. I mean, we've looked at the appropriate test, which is error of law or approach is one basis for interfering, or manifestly clearly inappropriate, manifestly excessive, however one wants to put it, is the other test. What they say at the end of 33 sort of is a compendious formulation which potentially covers both those tests. And it may be relevant in this case because at 36 and 37, as I was reading their judgment, they seem to deal with an error of approach.
Yes.
So that's one entry point.
Yes.
And they might be right about that. And if that's an error of approach, then the decision of the disciplinary committee could not stand, and they would have to exercise their own judgment, and the questions of deference would then just fall away.
Absolutely.
Yes. So what I'm just seeking to call attention to is the formulation at the end of paragraph 33 seems to sweep up both that possibility and the possibility that they're saying, well, even if there hadn't been an error of approach by the disciplinary committee, nonetheless, it was, in their view, clearly inappropriate.
Precisely.
And as I understand, you're maintaining that they would be right whichever way round
Yes.
it was put.
Yes.
Right.
But I don't, as it were, pin my colours merely to the mast of obvious error of law or some, when it's plain that the Court of Appeal will interfere.
Well, I think that's what I was putting to you, that you rely on both.
I do, exactly. So that's why I'm not relying only on
both
one.
limbs of the test in
Yes,
paragraph 30.
both tests, yes. Now, the two cases which I would seek to put at the forefront of our submissions, the first is the case of Salisbury, which is at page 645 in the bundle, in the electronic bundle. Now, Salisbury was a case of a solicitor who had, lordships remember, altered the cheque by inserting the figure 1 before 800 plus pounds, thereby adding 1,000 to a cheque that he asserted he was owed not merely the 800 plus, but he was owed the 1,000 in addition. So he'd altered the cheque. It's not clear from the report, for those of us who had decades of writing cheques, how he managed to change the words as well as the figures, but plainly he did. And he was struck off first, I think, and then, but then suspended for 3 years because it was felt that that was at the bottom end of dishonesty. And the passages I would draw your lordship's attention to, which are helpful in this case, is the court reviews, beginning on page 650, the leading case of the important case of Gauche, and then at paragraph 25, the case of Priest. Priest was a case of a dentist suspended for 12 months. So not a lawyer, at 25, and then the case of Langford, then the case of Burroughs, and at paragraph 30 on page 651, the Court of Appeal, which included, one should point out, the author of the Common Law Library volume on professional negligence, Lord Justice Jackson, concluded at paragraph 30, from this review of authority, I conclude that the statements of principle set out by the Master of the Rolls in Bolton remain good law, subject to this qualification. In applying the Bolton principles, the Solicitor's Disciplinary Tribunal must also take into account the rights of the solicitor under Article 6 and 8 of the Convention. It is now an overstatement to say that a very strong case is required before the court will interfere with a sentence imposed by the disciplinary tribunal. The correct analysis is that the Solicitor's Disciplinary Tribunal comprises an expert and informed tribunal which is particularly well placed in any case to assess what measures are required to deal with defaulting solicitors and to protect the public interest. Absent any error of law, plainly that is going to give a full ground for intervening, the High Court must pay considerable respect to the sentencing decisions of the tribunal. Nevertheless, if the High Court, despite paying such respect, is satisfied that the sentencing decision was clearly inappropriate, then the court will interfere. It should also be noted that an appeal that's the review point we need to look at.
Do you quarrel with any of that?
No, I'm not quarrelling with this. I'm saying that's our position on this.
Yes, well, it underpins paragraph 30 of the Court of Appeal's judgment.
Yeah.
This was a refinement made of Bolton based on the enactment of the Human Rights Act in the United Kingdom.
Yes.
Are there similar provisions in the Jamaican Constitution?
There are entirely, and I meant to. I overlooked it. I'm very sorry. I'm very sorry. I overlooked it. It was. It's on page 542 in the bundle, clause 16(2) of the Charter. Which, for all practical purposes, is the same.
It's the same as Article 6.
It's the same substance.
Yes, but what about Article... I was aware of this, so you referred to it earlier. What about Article 8?
Oh, I haven't got that in my head. I'll have to come back to that if your lordship will allow me to, because I'm sure that's in the Charter too.
Mr. Malins, there are subsequent decisions to Salisbury. I'm thinking of,
yes, there is.
I'm thinking of Khan in the Supreme Court, and I'm thinking of Sastry in the Court of Appeal.
Absolutely.
I wonder whether Salisbury is really. I mean, in substance, there's probably not much to quarrel with in the paragraph you've just referred to, but I wonder whether it really is the now the leading authority. And I think that the discussion of the area has really moved away from Articles 6 and 8.
Yeah, I agree with your Lordship on that. I just didn't want to go back to the last century and wanted to come
there's
as
no
quickly as
reason to
possible.
do that. We've moved quite a long way from Bolton, which was only in the 1990s.
Exactly. The case that, one of the cases your Lordship has referred to, which is an important case, is Sastry at page 662, and we would.
666.
I'm so sorry. Yeah, 666. Which contains, we submit, what is a very clear and accurate test and analysis of where the present state of the law is. And
well, two tests are identified.
yes, I can't just find them for a moment. Is it, what page 102? 69. It is 696. Yes.
I seem to have framed some issues at the start of the judgment, but I don't have any recollection of the case.
The discussion and conclusions begin at page 696. At the top of the page, paragraph 96, and there's no need to read that. And then 102, derived from Gauche, are the following points.
That's in a case where the appellate court has full rehearing jurisdiction rather than a review jurisdiction.
Yes, yeah. and that's what the Court of Appeal had in Jamaica.
Yeah.
So first, it points out 1021, an unqualified statutory right of appeal. That is the case in this case. The jurisdiction of the court is appellate, not supervisory. The appeal is a rehearing in which the court is fully entitled to substitute its own decision for that of the tribunal. For the appellate court will not defer to the judgment of the tribunal more than is warranted in the circumstances. The appellate court must decide whether the sanction imposed was appropriate, note the absence of clearly, and necessary in the public interest, or was excessive and disproportionate. In the latter event, the appellate court should substitute some other penalty or remit the case to the tribunal for reconsideration. And then the court addresses the place of a disciplinary decision in the thinking on appeal. The courts have accepted that some degree of deference will be accorded to the judgment of the tribunal, but as observed by Lord Millet in Gauche, the board will not defer to the committee's judgment more than is warranted by the circumstances. That's why I opened by my answer no to the question from the Court of Appeal. In Priest, Lord Cook stated that the appropriate degree of deference will depend on the circumstances of the case. Plainly, one can imagine a different kind, not the legal profession, some other profession where there's an appeal against conviction with rival experts giving evidence and so on. One can easily imagine a case where the circumstances are such that the Court of Appeal would be very loath to overturn the tribunal. Lord Justice Laws in Rashid and Fatnani, in accepting that the learning of the Privy Council constituted the essential approach to be applied by the High Court on a Section 40 appeal, that's a full appeal, stated that on such appeal, material errors of law, of fact and law will be corrected, and the court will exercise judgment. but it is a secondary judgment as to the application of the principles, protection of the public and so on, and the reputation of the profession, to the facts of the case. In Cheadle, Mr. Justice Cranston accepted that the degree of deference to be accorded to the tribunal will depend on all the circumstances, one factor being the composition of the tribunal. That may open a consideration which could be awkward. He accepted the appellant's submission that he could not be completely blind to a composition which comprised 3 lay members and 2 medical members. Then Khan, Lord Wilson, accepted diffidence and approved the test identified by Lord Millet in Gauche. It follows from the above that the Judicial Committee of the Privy Council in Gauche approved the Supreme Court in Caen had identified the test on Section 40 appeals as whether the sanction was wrong, and the approach at the hearing, which was appellate and not supervisory, as being whether the sanction imposed was appropriate and necessary in the public interest or was excessive and disproportionate. Those are the words I rely upon, and I do point out the absence of the word clearly. So that we, for Mr. Lorne, submit was exactly, in reality, how the Court of Appeal gave the approach that the Court of Appeal gave to this case. And if I can ask your Lordship to go over to page 110, my Lord Legate in this case, when Lord Justice, was the court that gave leave. And
sorry, what page?
Page 698 at paragraph 110.
Oh, yeah.
Accordingly, we agree with the view expressed by Lord Justice Legate that the judge in the Section 40 appeal of Dr. Sastry was required to exercise her own judgment as to whether the sanction imposed was excessive and disproportionate. It follows from the above that we do not agree that the court is ill-equipped to deal with it. And then halfway down the paragraph, as has been previously recognised, the court is able to arrive at a view of what public protection and the reputation of the profession requires. To describe the view of the court as being untutored pays no or little regard to the ability of the appellate court to evaluate issues of public protection and the reputation of the medical profession, that being medical, not even legal, and to its role demonstrated in previous cases in deciding whether the sanction imposed was necessary and appropriate in the public interest or was excessive or disproportionate. And then again, on this question of what is the place of a previous decision of the disciplinary committee at 112, appropriate deference is to be paid to the determination of the medical practitioners tribunal in Section 40 appeals, but the court must not abrogate its own duty in deciding whether the sanction imposed was wrong. That is appropriate and necessary in the public interest. In this case, the judge failed to conduct any analysis of whether the sanction imposed was appropriate and necessary in the public interest or whether the sanction was excessive and disproportionate and therefore impermissibly deferred to the tribunal. And then in granting Dr. Okpara permission to appeal, Lord Justice Legate identified between the authorities quoted and where a court of appeal can more readily assess whether a particular sanction is appropriate and thus give less weight to the tribunal. We conclude that the judge did fail to have regard to the line of authorities in those cases. And then below, 8 lines up, we agreed that in matters such as dishonesty or sexual misconduct, the court is well placed to assess what is needed to protect the public or maintain the reputation of the profession and is less dependent on the expertise of the tribunal. It follows that we find that the approach of the judge to the sanction imposed on Dr. Okpara was wrong, and that he did not assess whether the sanction was necessary or appropriate in the public interest, or was excessive or disproportionate, and then it goes on to deal with the other person appealing. So our submission, the Lords, is, as I said, in that in those paragraphs, particularly the paragraph 102 on page 696, derived from Goach, are 6 approaches, and then 105, which is a summary where the test is, was the sanction appropriate and necessary in the public interest, or was excessive and disproportionate? That's how we put our position on the current law. And those references enable the board to answer, we submit helpfully, the questions posed by the Court of Appeal, and when applied in this instance case to the Court of Appeal's reduction of life to 5 years plus further education, we submit that leads also to saying that in this case, on these facts, the Court of Appeal applied the right test and was right.
Can I just check, what had happened to Dr. Sastry in this case?
I think he'd lost, actually, out of memory.
At the disciplinary stage.
Ah. Yes, I'll make a note of that. You mean also, what had he done?
Well, no, I actually meant what was the outcome at each stage? So what was the sanction imposed by the disciplinary tribunal? What did the judge do for which the judge was then criticised?
My lord, I apologise for that. I should have, I went straight to the tests. I should have found out, as it was
maybe page 700, Dr. Okpara, is it? Or was it Dr. Sastry? Oh, Sastry, was it? Yeah.
Sastry. It was erasure, was it?
Yeah.
What?
699, yeah.
Yes, erasure, yes, it was erasure.
Yes, paragraph 2 of the judgment on 667. The first appellant, Dr. Sastry, challenges the order of Mr. Justice May dismissing his appeal against the decision of the Medical Practice Tribunal.
Yes, yes, he was struck off.
Yes, thank you.
But I didn't really want to go into the facts, because that's a doctor, and misbehaviour by doctors generally takes different forms. By lawyers, it often takes forms ranging from incompetence to dishonesty. It's rare to have...
Suppose we take the view that the Court of Appeal applied the correct test here, then is the position that unless we think that unless we think that their view couldn't be supported, we don't interfere with it?
Yeah, that is my submission. Yes.
So we don't, as it were, re-exercise their judgment?
No.
On this further appeal?
Unless, on this appeal, which is why Bolton is, that was actually the Court of Appeal. But on this appeal, the two questions asked are asked on the basis that did we approach it and how do we approach it correctly? If we approached it, generally speaking, correctly, that's the end of it. If we didn't approach it correctly, we approached it improperly, does that make any difference to the result? But we submit that they approached it correctly, and even if they didn't, if there's some kind of higher, more 20th century test, they still got it right.
Yes, can I just check that with you. So I'd have thought that the first question is whether they adopted the correct approach to interfering with the decision of the disciplinary committee.
Yes.
We've already discussed there are two limbs to that. They might have misdirected themselves, or they, the disciplinary committee might have imposed an excessive punishment.
Yes.
And you rely on both.
I do.
If the Court of Appeal was entitled to go behind the decision of the disciplinary committee, I haven't detected, and indeed I think counsel for the appellant made clear that there isn't an alternative case being presented for the GLC that the Court of Appeal in turn went wrong. The reason that I'm highlighting that is, I mean, we had some discussion of what is said at paragraph 39 in the Court of Appeal, page 79, about naivete, not having experience in practicing in the area of conveyancing, about which potentially one could have a debate. But I don't think it's said by the appellant that if the Court of Appeal was entitled to go behind the decision of the disciplinary committee, that we should, at that point, set aside the decision of the Court of Appeal because they had regard to irrelevant considerations or anything like that.
No, I agree, except that the submissions seeking to introduce, as it were, more elements of bad behavior to justify the disciplinary committee's view elided perhaps into a little bit that should have more influenced the Court of Appeal. But
just so we're clear, I understood those points to be made in support of what the GLC itself
absolutely,
had done.
If that's all.
So it was a defensive submission to seek to persuade us that the Court of Appeal had no right to go behind what they had decided. I didn't myself understand those to be separate criticisms if the Court of Appeal was entitled to go behind the GLC's decision of the Court of Appeal's own decision.
But there's a further question, I think, which is whether the judgment about whether the sanction was excessive and disproportionate, if the Court of Appeal take a view that it was, whether we should be second-guessing that judgment.
No.
But, right. But doesn't that go back to the question about due deference? Yeah. So, well, if I might say so with respect, I don't think that one can just go to say, well, the Court of Appeal did something which one could defend as proportionate, and therefore you don't ask any further questions. Speaking for myself, I'd have thought that you have to ask the prior question. Did the decision which was made by the GLC, putting aside error of law and just looking at the excessive nature of the penalty, did the GLC overstep whatever the parameters were to be accorded to their decision on grounds of due deference? I mean, if they didn't, the fact that the Court of Appeal formed its own view would just be one of those cases where a court on appeal can form a different view. But that's not enough.
Lord, in the two questions, taking it in stages, the first one is whether the sanction imposed by the disciplinary committee was, and then a whole series of phrases are used. That being the question, the route to the answer to that question can include in it the Court of Appeal's approach. Obviously, because the Court of Appeal applied the correct tests and took an informed, different view, whilst paying due deference to the fact of the disciplinary committee's decision.
But I think it's fair to say that the appellants in their case do take issue with the Court of Appeal's analysis of the relevant circumstances. For example, they take issue with the Court of Appeal saying that this was due to Mr. Lorne's naivety and misunderstanding the position, and also they take issue with the Court of Appeal's reliance on him having made full reparation. So I think there is a challenge to the decision reached by the Court of Appeal here?
That was precisely, my Lord, where I felt I was being stopped.
Which is exactly, incidentally, the question, which is the first question raised.
Yes, that's precisely why I was seeking to address some of the points.
Well, that's right.
When I was stopped.
So the only point I'm making is that I think the board is invited to consider whether the decision of the Court of Appeal was a correct decision or not.
Absolutely, that is the question. And if I can, there is just one passage in the decision giving leave to appeal, which was by a different Court of Appeal, on number 10, where this is a bundle, page 101, where the Court of Appeal recalled at paragraph 31, I do not find the disputed issue between the parties of whether the respondent had given an undertaking to the complainant to be a relevant consideration. The issue did not arise on the appeal, was not an issue determined by the court in coming to its decisions. Furthermore, the disciplinary committee did not demonstrably establish that its decisions were influenced by any undertaking the respondents had given to the complainant. Finally, it must also be remembered that the respondent was never charged with breaching any undertaking in contravention of the canons. Therefore, in challenging the court's decision, the GRC must fail in this attempt to rely on what it alleges to be the respondent's failure to honour an undertaking. It's a simple, in a sense, factual case. He was charged with failing to account for client money. On that, he was convicted. The circumstances range from idiotic ignorance of the law that imposed upon him a trust, right the way through.
Which he accepted.
Which he was a trustee.
He wasn't ignorant, idiotically or otherwise.
Yes,
he knew that he was a trustee.
Yes.
And he knew which laws imposed.
No, absolutely, he knew that. So the question then is why? Why did he do that? The answer to that question is, and it was accepted, that he was persuaded by the brother of these two siblings that prior to the distribution, the sister had enjoyed more than her fair share of the income from the estate, and therefore it was fair to send the whole of it to him. That's it. Now, that could be described as extremely naive.
Well, I don't know why naive.
Well,
I mean, just completely inexplicable.
Well, in a sense, it has to be explained absent dishonesty.
Well, we don't know. I mean, all we know is he accepted the word of the brother. He knew he was holding this money for his clients, the brother and the sister.
Yes.
He's given this explanation by the brother. He doesn't check it with the sister. He just doesn't pay her.
I quite agree.
So it's just a completely extraordinary breach of professional and fiduciary duty.
It was.
It's difficult, short of dishonesty, to think of a more serious one.
Well, the mind can think of more serious...
Mine can't.
Well,
short of dishonesty, Mr.
Dishonesty isn't the only form of egregious misbehaviour by those in...
This was not egregious.
I'm not. I'm simply saying that one isn't only looking at pocketing money cases. I mean,
he didn't pocket the money. It's accepted he didn't pocket it.
Supposing he had misused his power over the monies to demand benefits from the lady, that would be a terrible case.
Well, it would
I
certainly.
mean, one can't, as it
It's
were,
difficult to imagine it being anything other than dishonest, however.
probably dishonest as well. But what I'm submitting is...
I think the point is that the Court of Appeal suggested that this was the result of naivety and not being familiar with areas of the law in which he said he practiced. There was absolutely no evidence for the Court of Appeal's view about that.
The Court of Appeal were speculating as to
Well,
the
they shouldn't
mind.
speculate. I mean, that's not a proper basis for them to reach a decision.
They reached their decision on the basis that no dishonesty was found.
Yes, but they shouldn't then have speculated, should they, that it might be due to Mr. Lorne's unfamiliarity with the administration of estates, given that Mr. Lorne had himself said that that was one of the areas in which he practiced.
No, they shouldn't have, but because you should start. But can we finish, my Lord? You start from the proposition that a lawyer who holds him or herself out to provide a legal service to the public is qualified to do that, and that means knows the relevant law. Right? Why he didn't fulfil that obligation is a matter for speculation, absent pocketing the money or some other kind of extraneous benefit. One simply can't say, but the Court of Appeal didn't decide it on that basis.
Well, I don't know. I mean, they say in paragraph 39, although they're saying that this was a flagrant departure from acceptable professional standards. They do in paragraph 39 say, it seems that the appellant's conduct in this case and in relation to this complainant could very well have come about due to a lack of familiarity with the law and practice in the area of conveyancing and probate of wills. Well, there's absolutely no basis in the evidence for that statement.
Well, with respect, the inference from giving the entirety of an estate to one of two equal beneficiaries can only, absent dishonesty, can only be a situation that you don't know or you have forgotten the law.
I don't think that can possibly be followed.
Well, I can't think of any other possible reason for doing something like absent dishonesty for when your duty is to give £50 to A and £50 to B, you give £100 to A.
Anyway, you say that...
You quite easily postulate a case where somebody does know the law. If you ask them the question of law, they'll give the correct answer. But they operate in such a unthinking and haphazard way that they don't actually think about it and apply the law in their actions.
Chaotic, in a chaotic way.
And there seems to be ample evidence of that if you look at the respondent's failure to attend the various hearings.
No, I quite agree.
He behaved disgracefully, but he's very fortunate that the disciplinary panel focused simply on the complaint that the client had made.
Which led to the charge, which was the charge.
Yes. He's very fortunate that they were so confined in their focus, equally ignoring prior encounters between the practitioner and the disciplinary committee. But anyway, I think this is a matter which we should come back to after the short adjournment.